Now I'd like to introduce our next speakers. We've got Brian Hitchcock and Emma McCartney, who are going to take us through case law update. Brian and Emma have a background in contentious litigation for Emma, and Brian works on a number of large procurement and complex civil engineering and construction projects, and is also doing a number of projects in space and also the ports sector. So I'll now hand over to you, Brian. Thank you.
Great, thanks very much. Yeah, we've just started using NEC contracts for the floating offshore wind gear up actually in the Celtic Sea, because we're trying to actually move some of that out of Royal Industry Logic contracts. So I'm really hoping there'll be lots more use of NEC in that particular project this time. Okay, what are we going to be talking about today? This is just a quick update on construction law that we think would be relevant to the theme of this conference, which is of course driving change. We've been through probably the last 2 years worth of cases, and we found some reoccurring themes, so I think it's probably worth us just going through that. There's similar sorts of things that have been going on for a few years, but we've highlighted about 6 cases out of probably 20 I think we originally located, so we'll run through those. I'm a front-end construction lawyer and I also do dispute avoidance, so I'm going to focus on those first 2 and also communications protocols. So that's, you probably are familiar with the case of Van Oord versus Dragados. And then I'm going to come on to talk about Brackpool Borough Council versus Volker Fitzpatrick, which is about getting your scope right, which is where we see a lot of disagreements within NEC contracts. And then Emma's going to focus on that ever-present topic, which is getting your payment notices right, and also specifically under NEC, obviously a notice of dissatisfaction, because we've been seeing a real stream of those cases coming through over the last 2 or 3 years. So, and then very lastly, the communications protocol. I think this is, particularly relevant for this conference. We've got a lot of clients, certainly those in the nuclear sector and some of the bigger projects, who are really drilling down on clause 13 and looking at what that wording means when something goes through a contract with NEC. So it's the interrelationship between NEC and the communication system, like Fast Draft, and the other one I'm not going to mention, I think. I'm supposed to say that. But, right. Okay, so the first case, Van Oord versus Dragados. So this is a case basically about omission of work, and also it's a really good rehearsal of good faith obligations within NEC. So I thought it worth just running through that. This is a case to do with the Aberdeen Harbour expansion. It's a dredging case, and Dragados subcontracted certain parts of the works to Van Oord for that dredging. In fact, it was a very large subcontract. It was about 2 million cubic metres of dredging work. It was done under NEC 3, subcontract option B with a bill of quantities. The contract was entered into March 2018. Now the important point here was that Van Oord's tender had a blended rate for the dredging, which was 7.48 per metre cubed. So everything was going fine until Dragados instructed an omission to Van Oord's scope, and they actually did it twice, and then they tried to, well, they did actually give the work to other subcontractors, which obviously upset Van Oord quite a bit. There were 2 omissions, actually. The first one was in June 2019. That took the rate down to 5.82 pounds per cubic metre. And then they did a second one in September 2019, which took it down to 3.8. So that's a significant reduction in the rate. And especially when they actually gave the easier work to the other 2 subcontractors, and Van Oord were left with the more difficult dredging work. So it's not surprising that kicked things off. So yes, there was an adjudication about that reduction in rate due to an instruction given to omit works. Now, as a drafter, I focused in here on particularly clause 14.3, which I put up on the screen. So the original 14.3 is in black, and then if you look just below, you've got the amendment, which is the amendment which allowed emissions under the contract. So the court looked at this and it applied the standard case, contract law case of Abbey Developments, 1987. That's well-rehearsed law in terms of when you obviously you give work to a contractor, you should allow them to actually carry it out and realise their project. If you want to omit works, then you need to use very, very clear words in the contract to do that. So now going back to the clause that's up on the screen, you can see obviously 14.3 in its original form doesn't really talk about emission. So that doesn't quite tick the box of clear words. But the second part in red certainly does. I mean, I think it's a fair attempt. It's quite similar to what we might draft, subject to a few comments. The emission happened, and Van Oort actually argued that it was in breach of contract, and the reason that they thought it was in breach of contract is due to the underlined bit, which I've put up there on the screen. So for that emission clause to actually work, there needs to be a corresponding instruction issued by the PM under the main contract, and that's not what happened here. So that was the test that wasn't actually ticked for this. So therefore, it was an unlawful change which was actually given in accordance with this clause. So now the judge at the Outer Scottish Court said, well, okay, fine, but surely, as we know under NEC 3, breach of contract is also a compensation event, so surely the same mechanism applies. And it went on to say that, but it also said that the reduction in rate would stick. So, and as I've said, because Van Oort were left with the more difficult work, they had a problem with that. Interestingly, in the last point on the slide, the judge didn't think that clause 10.1, our favourite clause, mutual trust and cooperation, didn't actually add anything to this, which is kind of strange when you think that it's a breach of contract. Okay, so on appeal, the judge did think that clause 10.1 added something, and it went on to do actually a really good rehearsal of what we understand the principles of good faith are at the moment under NEC, and it ran through those three propositions which are up on the screen. The first one, a contracting party will not, in all normal circumstances, be entitled to take advantage of its own breach. A subcontractor is not obliged to obey an instruction issued in breach of contract. And the third one, clear language is required to place one contracting party completely at the mercy of the other. What's interesting about those cases, those in Scotland, they are all senior English cases. So they were cases in the House of Lords and also in the Court of Appeal. And that's important when you think, does this actually apply to us under English law? So the bullet down at the bottom, the court did think that clause 10.1 and 63.10 were counterparts. And if you look, I hope you can see this up on the screen, 63.10. Therefore, if that's an unlawful change or instruction coming through the contract, the prices aren't reduced. If it was a lawful change, if that instruction had been given under the main contract, perhaps this would have worked against Van Oort. Okay, so what are the takeaways for that? Obviously, draft and use emission clauses, very carefully. Do read them when you use them. It's probably one of the few things I think as a front-end drafter I get asked to do quite a bit. Although not quite in the context of this. Normally it's about agreed bits of work between the contractor and the client that they agree can be unplugged, quite often without a compensation event mechanism. But that's a commercial agreement, so slightly different to what's going on here. So then, does this affect us in contracts that are subject to English law? Yes, I think it probably does. One, because, as I've already noted, some of the theories are based on English law senior cases. And as we know, a Scottish case is persuasive also in the UK courts. So I think it is something to bear in mind. Quite a recent case. I would recommend actually reading through some of the judgment, because it's a very good rehearsal of good faith within contracts. Okay, so that's the first case on a point of drafting. The second case is Blackpool Borough Council versus Volker Fitzpatrick. This is some works that took place actually quite a long time ago. So the works were complete in 2011. It was so Blackpool engaged Volker Fitzpatrick to actually build a tram depot, quite a significant depot. Everything was okay until there was a storm in 2015 and part of the roof blew off. Blackpool Borough Council went into the roof and started looking around, and they found that a lot of the steel components actually within the roof were extremely corroded. So they put in a breach of contract claim against Volker Fitzpatrick, alleging that it did not meet the intended design life of 50 years. Quite a significant thing. Also, don't forget that this case also applied MT Hoggard, which is that clause, which is the interplay between duty of care and a direct warranty. So that clause directly applied here. Something we look out a lot for, certainly for contractor clients. Something that needs to be discussed quite a bit, I think. So that's actually NEC2. It should be up on the screen because obviously the works were quite old. So we're talking about inconsistencies within works information, and we're talking about a hierarchy clause here. So what did the contract actually say? Fifth bullet point down in the works information, this is part 1 contract data, so employer's side of the contract. It stated the design life should be 20 years unless otherwise specified in the functional performance specification. Functional performance specification required the building structure should achieve a 50-year design life. Now actually when the court started looking at the works information, it couldn't find that definition of building structure. It looked for implied other cases, it looked for definitions in the British standards, but of course there isn't one. So that was the point that was hotly looked at within the contract on a factual basis. Interestingly, for those of you the interplay between different sides of the contract, the contractor's works information had a design log attached to it stating the design life was 50 years for the structural frame, not the roof elements, and 25 years for the external shell. So that's worth bearing in mind. Okay, what did the point of drafting, what did the contract say? So it had a standard, you've probably seen clauses like this, which seeks to invoke hierarchy in the works information. In the event of an inconsistency, the council's information takes priority over the contractor's works information. And as I've already said, when the court really started drilling down on what the definition of building structure was, it couldn't find it. So there was therefore no inconsistency within the contract, and therefore the court actually read the documents as they were. That hierarchy didn't come into play in this one. That meant the roof components had a design life of 20 years and not 50. At the end of the case, actually the roofing components, because there was a lot of corrosion in the roof, it wasn't actually deemed a defect because there was a sacrificial coating around the steel, so that claim actually didn't go through. But there were several others that did. What are the takeaways of this? A priority clause can't be relied upon where there is no inconsistency within the documents. This is applying the old case, you probably remember, well not so old I guess, but RWE Bentley 2014, which had a great discussion of this. That was to do with contract date. I think there was a completion date between the one in the contract data and the one in the works information to do with damages for late completion. So it applied that same case.
Can I ask a question?
Yep.
So, presumably it's within, this is directly under, applying directly under the contract, so it's within 13, what is it, it's a sealed contract, is it? Or is it a claim under the professional indemnity insurance?
No, this was a straight claim between
Yeah.
Blackpool and the contractor.
But if it had been after the 13 years, or what's the end of the sealed contract maximum life? They couldn't have claimed, could they?
They could have done. Well, no, they did. This is well, it's just inside. I think
Yeah.
the completion date was 2011.
Yeah,
So therefore, 12 years. It's a deed.
12 years.
So you're within time on that one. So just a few more takeaways. Preparing works information. It's. I mean, I'm an ex-civil engineer. We spend weeks sometimes actually going through the works information with the client. I think it's probably the single thing, if you're going to spend some time, is making sure you go through that works information. Because some of these hierarchy clauses can lead you into a bit of a false sense of security. You think that will apply, therefore I'll invoke that. But that's not the case, because the court will actually look and read the contract documents together and come up with a solution before it actually gets to that stage. So, yes, please do draft your work information really well. I put up the last bullet point is obviously that great publication, How to Write Works Information. Fantastic, then updated at NEC 4 stage. So if you're not going to engage a professional consultant to actually write it, which I highly recommend, those provide a really good start to do that. Okay. Right. Now this is a personal interest of mine. So clause 13, contract management systems, how do they interact? I think we're getting to a slightly new stage, and I'm seeing quite a few amendments to this clause to actually keep pace with what we're doing in the digital world. So up on the screen I've got, you'll probably recognize these. The top left is NEC 3. The middle one is NEC 4, clause 13, and the bottom is the scope guidance, which I highly recommend. But if you could focus in on clause 13, 13.1, I think we know what that means in writing. I think that's relatively settled, so we won't discuss that. But 13.2, if the scope specifies the use of a communication system, communication has effect when it is communicated through the communication specified in the scope. And it's that word "through." Certainly, as a front-end construction lawyer, I get a bit twitchy about. So we've had a bit of a think of that in the office about what that means. We've contacted friends who have their own contract management systems, thinking that if you just specify it, what does that mean? What does "through" mean? Quite a few of these actually say, completed successfully. The submission's been successfully uploaded, and then quite often there's an email sent. So does that mean "through"? Is that what it means? And I think that's probably the case, especially if people are, during the course of their dealings, are relying on that. But it's not that simple sometimes on some of the bigger projects. Certainly some of the nuclear ones we do, there are multiple systems for submissions of documents. They will use different document management systems to submit things through. And they will also use FastDraft, not the other one, to do that sometimes. So I think it's worth having discussion about that, and we are seeing quite a bit of drafting about how those things are actually dealt with. So you could end up with almost a sort of two-layer. So one is the actual definition of what "through" means, but also which documents should come through which system and the general interplay with that. It's particularly important when you think, if you look at 13.2 and you drop down, it says if the scope does not specify a communication system, then you're into the old NEC drafting, but of course it doesn't get that far unless well, when you've actually engaged the communication system. So there's another reason to actually look at this. Simple amendment, in other words, things don't take effect generally unless they're done in accordance with the communications protocol. So,
Right.
so that's that.
Can I just ask you to stop for a second? I've got a problem with your microphone.
Yep.
Could we just ask you just to take the bell pack out of the pocket, just on the top of the switch, in case you might be muted? You could just unmute it. If you're on the live stream, we're just having a show in the some very top of the switch. Right on the very top.
Mute.
So, now showing unmuted.
It's now turned off. Hello? Can you hear me?
Sorry, everyone.
That's going to want some music. Great. I'm just looking at my timing because I think Emma's on in a minute. Right, that was that slide. I won't go through this one in too much detail. Suffice to say, we have a lot of people around the business churning through real estate law, IT law, trying to work out what the definitions are in this word through. And we've been back, Law Commission guidance, all that sort of thing, to see if there's any law around this. There is law on clause 13.2, which I think is really important. That's quite an old settled case, which says 13.2 is the exclusive method of effective delivery and communication required by the contract. So we do have some NEC case law based on that. But it then becomes doubly important, doesn't it, to make sure that if you're using a communication system, it thoroughly defines how you're actually going to submit communications. Right, and then some of the other points, without going through all that case law that we've trawled through, is in practice, if a dispute actually develops on this, and we quite often see this, the court is going to look at actually the facts of the case, because quite often, we see this in quite a few projects, maybe one part of the contract management system wasn't complied with, they started doing something, they were issuing emails, they were running things around to the office, so inevitably it's actually going to come down to what people actually did when you look at it. And that becomes quite difficult actually, because the definition of receipt in English law is very, very difficult to interpret. So anyway, I hope that's been useful. I think it's a larger discussion around that 13.2. Do we draft a communications protocol? Do we use a contract management system? How does that fit together? I think it's quite an interesting point. Anyway. And with that, I'll hand over to Emma, who's going to talk to you about payment notices and notices of dissatisfaction.
Thank you. Okay, thank you everybody for being here today. Hopefully I'm not on mute as well. Please let me know if you can't hear me. And thank you to Brian. So I'm going to talk today about notices. It's fundamental to any construction contract, NEC or JCT. I'm going to predominantly speak about notices of dissatisfaction and pay less notices. Now, in my day job, I'm a dispute resolution solicitor. Unfortunately, I do have to give clients bad news sometimes when they've not served a notice correctly. So I say it's really important to get timely legal advice. I've had situations in the past where pay less notices have been served 24 hours too late, and a tricky situation to deal with. And notices of dissatisfaction sometimes just don't have the contents that they need to in order to get your case heard at a tribunal. So firstly, we'll do notices of dissatisfaction. It's a really interesting case, Ravestein versus Trant. It's an adjudication, but the details of which are not that, we don't need to go through it in much detail as the notice of dissatisfaction itself. Suffice to say that Trant became unhappy with Ravestein's engineering works. They were defective. They referred it to adjudication. What's interesting is Ravestein wasn't engaged with the adjudication at all, really, and the adjudicator subsequently found in favour of Trant to the tune of £500,000, at which point Ravestein became very animated and wanted to engage quite a lot. So they quickly fired off an email to the adjudicator. That was the first mistake. If you're sending a notice of dissatisfaction, it has to be to the other party, not to the adjudicator. It wasn't fatal, though, because they copied the other party in. So the first email simply said that they were unhappy with the jurisdiction of the adjudicator, and that was quickly followed by another email, which is what they relied on as their notice of dissatisfaction, which is on the screen. So if you have a quick look through that email, that notice of dissatisfaction, what we're trying to look at is whether that notice complies with the clause W2 of the NEC 3, which I'm sure you're all very aware of. So what do we think? Do you think that that complies with the NEC 3 clause? Does it give enough information? I can tell you it was to the right person this time, and it was in date, so it was given within the 4 weeks of the adjudicator's decision. But it doesn't look like there's too much there, does it? And I can tell you that the solicitor, Mr. Hugh Smith, didn't draft that notice, and I always wonder whether it would be a different outcome if he had. Who knows? So, Ravestein wanted to refer to an arbitrator. The first decision of the arbitrator was that notice of dissatisfaction valid under the contract? There is Ravestein's arguments on the slide. And no, the arbitrator found that it wasn't sufficient to be a valid notice of dissatisfaction. Didn't have enough information in there. There are 3 prongs for a valid notice of dissatisfaction. That is, it has to be in time, 4 weeks from the adjudicator's decision. It has to tell the other party that they want to go to tribunal, and it has to give the merits and what are you unhappy with, what are you dissatisfied with, what merits of the adjudicator's decision are you dissatisfied with. And that has to be enough information for the other party to understand why you're unhappy. Otherwise, they just simply won't know why you're trying to go to a tribunal. So it's really important to get those elements right. Ravestein still wasn't happy with the arbitrator's decision and tried to go to court. Unfortunately for them, the court agreed with the arbitrator, and the adjudicator's decision of an award of £500,000 was enforced, and they had to pay. So the lessons learnt: make sure that you've got enough information in your notice of dissatisfaction, make sure it's going to the right person and served in the right amount of time within the 4 weeks, and then you should be able to go to your chosen tribunal once you've got that valid notice in. So the next case is also notice of dissatisfaction, goes a little bit further here. So it's NEC 2, don't see many of those these days. The works were completed well over 10 years ago. The parties engaged in many standstill agreements between then and now, and the adjudication was in 22. So the clause N93.1 of the NEC 2 was a forerunner to the dispute resolution clauses which are in the NEC 3 and 4. But it's very similar, so you still have your 4-week timescale, you still have to give it the notice to the other party, and you still have to tell the other party what you're dissatisfied with. So here, the Sefton Council referred to adjudication. Allen Build had many defective works at their leisure centre that was to be constructed, and the adjudicator found in favour of the council to the tune of about circa £2.2 million this time. So this is the notice of dissatisfaction which is on the screen. This is what Allen Build relied on. So as you're looking at that, you can see that it's weightier, it's chunkier than the last notice of dissatisfaction that we saw in the case of Trant. But does that comply with the clause 93.1 of the NEC 2? Just have a think about that. I've put in red in the notice of dissatisfaction what I think you should focus on, and that's the wording of to the entirety of the adjudicator's decision. So really they're covering all bases there. They're trying to say that there's a jurisdictional challenge and I'm telling you that I'm unhappy with the merits of the adjudicator's decision, but I've said I'm not happy with any of it. Is that okay? Is that too wide? What do you think? Really encompasses everything. So let's find out what they thought. So can you challenge on the basis of merit and jurisdiction without splitting those two things up? Well, no, you can't. So the tribunal in this case was the court. The adjudicator's decision was enforced on the basis that if you want to challenge the adjudicator's decision for a jurisdictional reason, as opposed to the merits, you can do so within the same notice, but you really have to split those two elements out. You have to be very clear. You don't have to go so far as giving your submissions, because that's what you'll be giving to the tribunal in due course. But you do have to make sure that a reasonable recipient of that notice understands why you want to pursue, why you want to go to tribunal and have your matter heard there. So that's the lessons learned and takeaways from that. So I'm going to move on to pay less notices. So this was a really interesting case, which is quite recent in 22, again an NEC contract. So can one pay less notice apply to two different applications for payment? When I was reading this, I thought common sense has to prevail here. Surely you have to have a pay less notice for every application for payment, but an interesting argument was put forward as to why it doesn't always have to be that way. Again, the adjudication itself isn't really relevant in the facts other than it was a smash and grab adjudication based on there only being one pay less notice. So the relevant dates of the applications are there for you on the slide. There was one pay less notice against applications 24 and 25. So when we think about pay less notices, in this case the contents was there, it's just that the pay less notice didn't refer to the application in question. So in this case they were actually using an online system such as FastDraft, I won't mention which one, and what they had unfortunately forgot to do was to refer to application 24. However, it was in time. So Advance's legal team thought, oh, how can we get around this? And they decided that we could put forward an argument from the Housing Grants Construction Regeneration Act. So they specifically looked at section 1114A, which says that your pay less notice only has to give the sum that you consider due as at the date of that notice. So surely that will encompass all extant applications for payment. I'm giving you that notice on the 25th of November. I don't consider any sums due from any time. That's a really interesting argument, don't you think? Because normally you have to link it to the application for payment or the payment cycle. So the courts don't take too kindly to people that are trying to circumvent the Construction Act and thought, I'm not having this. So they thought, good try, Advance, but look at section 1113. So here, the payer has to give the payer's intention to pay less than the notified sum. Where do we find the notified sum? It has to be in an application for payment, payment certificate, and you have to refer to it. Otherwise, how will I know what I'm paying less than? So you have to refer to the application number or payment cycle number, but it can't be any other way. That is really the common sense view, and that's what I thought when I read this case, but it's good to have it there in writing. That's Aniska's argument and Advance's argument set out on the slides. You will have a delegate pack, I'm sure, by the end of the day. You'll have those slides with you, but it's good to have the court's decision in your pack. So when we're asking the question, can one pay less notice apply to two different applications for payment? No, please don't do that. A pay less notice has to refer to the application for payment or the payment cycle. It's really important to remember that. And the courts will uphold the Construction Act. So make sure that you're looking at your contract and be aware of the Construction Act as well, because you cannot circumvent that. So the wording of Justice Joanna Smith there, confirming her judgment. And that's really the takeaway for pay less notices. I mentioned your delegate pack. I'm not going to go through this slide. However, it's something to take away today as a crib sheet. If you're not using Fast Draft or the other one, then you can have a look at this. It's the 4 W's and H of how to give notices and best practice. But you can always come and talk to us in the break. We'd be happy to answer your questions. We did recently give a training session to a major contractor on the service of notices and contents of notices. So if you have got any training requirements, please bear us in mind. Please come and talk to us in the break. We can also provide training with Built Intelligence in collaboration with them. So please do come and talk to us in the break. We'd be happy to speak to you. That's our faces again. I'm sure nobody wants to see that. Okay. Well, thank you for your time this morning.